Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 263. As all we know that an order passed by the assessing officer can be revised by Principal Commissioner of Income Tax under section 263 if the order is both erroneous and prejudicial to the revenue at the same time. If any of the condition is missing, then revision under section 263 cannot be done. For understanding this case, it is very important to know that any order due to which the income tax liability of the assessee is not increasing, it does not mean that the order is prejudicial to the revenue. And the second issue regarding erroneous is that if the assessing officer has not made the inquiries during the assessment proceedings, then broadly an order passed by the assessing officer can be said to be erroneous. This issue has come before Ahmedabad ITAT-B bench in the case of Madhya Gujarat Vij Company Limited versus Principal Commissioner of Income Tax. This case has been reported in 110 ITR Tribunal Short Notes 21 and the date of the judgment is 2nd February 2024. This case relates to the assessment year 13-14. In the present case, after passing the assessment order by the learned assessing officer, Principal Commissioner of Income Tax issued the notice to the assessee under section 263 on the ground that there are 3 irregularities noticed by him in the assessment order. These 3 irregularities were regarding incorrect allowance of interest accrued, wrong claim of bad debt by the assessee, and incorrect allowance of provision on account of leave encashment. When the assessee received this notice, assessee submitted his various explanations, documents regarding all these irregularities noticed by the Principal Commissioner of Income Tax, and when the assessee submitted its explanation along with documents, the Principal Commissioner of Income Tax was satisfied that all the allowances have been claimed by the assessee correctly. Now the question was that if the assessee has not submitted various documents and explanations, or the assessing officer has not made the inquiry at the time of the assessment proceedings, but when the notice has been issued by the Commissioner of Income Tax under section 263, all the documents have been submitted and the explanation found to be satisfactory. So the question arises whether in this case also the assessment order can be said to be erroneous. In the present case, after being satisfied, the Principal Commissioner of Income Tax ordered for the section 263 revision. The assessee filed an appeal before the tribunal, and the tribunal said that when all the conditions of section 263 are not met, meaning thereby that the order is now neither erroneous nor prejudicial to the revenue, then in that case the order cannot be done for doing the revision under section 263. Since the assessee has submitted all the queries of the irregularities and the Principal Commissioner of Income Tax was satisfied with that explanation, so the order was not now erroneous, and since the allowances were rightly claimed by the assessee, so it can neither be said as prejudicial to the revenue because all the allowances have been claimed by the assessee in a right perception. Friends, the importance of this case increases nowadays because we see that nowadays a lot of revision are being done by the Principal Commissioner of Income Tax on the pretext that the order passed by the assessing officer is erroneous and prejudicial to the revenue. So when the order is erroneous or when it is prejudicial to the revenue is to be understood in a right perception from the provisions of section 263. Every order because of which there is some less tax liability cannot be termed as prejudicial to the revenue. At the end of this video, once again I am repeating the name of the case. The name of the case is Madhya Gujarat Veg Company Limited versus Principal Commissioner of Income Tax, and this case has been reported in 110 ITR Tribunal Short Notes 21. The matter has been decided by Honorable Ahmedabad ITAT B bench and the date of the judgment is 2nd February 2024. Thank you, friends.